A situation where you've got mum and dad of a couple, so mum and dad with adult kids, and one of the adult kids is going through a relationship breakdown. And invariably, if there's wealth up the tree, so wealth at the mum and dad level, the estranged son-in-law or daughter-in-law, as the case may be, will say, well, look, I can see the balance sheet for my former spouse as they sit here today, and I understand that, and there might be a separate argument in relation to whether the assets of the family trust are exposed. Yep, all good. But I've got reason to believe that under the estate plan of my former in-laws, that my ex-spouse will be getting a fair entitlement under their estate plan. So on that basis, I want to get access to the documentation that sets out how their estate plan works. Or I want to get access to how the family trust is set up. I want to get access to all the distribution resolutions that have been set up over time, even though it's not a direct asset or something that's directly within the portfolio of my spouse. It is within their overall family unit, and therefore I am entitled to get access to those documents. And the case law here is unclear. In one word, it is a little bit unclear. There are certainly cases to support the fact that a parent's estate planning documentation can be accessed, and there are actual anecdotal cases that we're aware of where that has been the case, and it's even down to the extent that in the actual trial, the parents-in-law are brought into the room, the doctors are brought in, there's medical certificates that have to be provided to say, well, look, even if the daughter or the son is entitled under the estate plan, we need to make an assessment of how mum and dad are tracking and whether they're actually going to die anytime soon, so we can actually start putting a monetary value on what that entitlement might be out of the estate plan. So it's really, on a number of levels, it's probably a very uncomfortable set of circumstances, but one that we're seeing more and more of. We've got it here on this next slide. As a general rule, the estate plan of a parent should be privileged. Nolan's an interesting case because they'd actually released all of the material around the estate plan to the former son-in-law, I think it was, before then a lawyer piped up and said, well, hang on, isn't this actually privileged? Isn't this confidential to the parents and the former parents-in-law? And the court held, well, yes, as a general rule, it probably would be privileged. But the reality here is you'd already released information, and therefore we can't let privilege attach to it. The privilege is the client's privilege. Once they waive it, well, that's actually the end of that discussion. So really, really interesting case study example there.